Today we are handing down the judgment in a case called Serafin against Malkiewicz and others. And I now want to explain the basis of the judgment. Mr Serafin, who is Polish but has lived in London for many years, has sued the editors and publisher of a Polish newspaper which is published in London for the benefit of the Polish community living here. He claims that 13 statements in an article which they published about him were defamatory of him. After a long hearing, a High Court judge dismissed the claim. He held that one of the statements had not caused serious harm to Mr Serafin's reputation, that others were substantially true, and that even in relation to the remainder, the claim failed because the whole article was on a matter of public interest. The defense of public interest is provided by Section 4 of the Defamation Act 2013. Mr Serafin, who represented himself before the judge, appealed with the assistance of counsel to the Court of Appeal. A major ground of his appeal was that the judge had been wrong to hold that the defense of public interest had been established. But he added another complaint. It was that the judge's conduct towards him had made the trial unfair. The Court of Appeal allowed Mr Serafin's appeal. It agreed that the defense of public interest had not been established. Overarchingly, however, it agreed that the trial of the action had been unfair to him. So it's the newspaper that appeals to us. The basis of our decision today, which I stress is unanimous, is that the trial was indeed unfair to Mr Serafin. On that basis, although we vary the Court of Appeal's order by ordering a full retrial instead of a partial one, we dismiss the newspaper's appeal. A heavy responsibility lies on an appeal court when required to decide whether a judge's interventions during the hearing exceeded reasonable attempts to focus the case, and if so, were not merely unfortunate, but unacceptable. In a schedule to today's judgment, I've set out 25 passages from the transcripts of the hearing. Some of them merit only minor criticism, but taking them together, although remembering that they were spread out over a long hearing, we are driven to agree with the Court of Appeal that from an early stage, the judge revealed such hostility towards Mr Serafin's case, expressed it in such ill-tempered, even offensive language, and so harassed and intimidated him as to have prevented him from putting his case properly. The result, of course, is that it could not have been fairly considered. So what about the defense of public interest? The Court of Appeal made various comments about it, which, with respect, we regard as misleading. The defense in Section 4 of the 2013 Act replaced a common law defense, which had famously emerged in proceedings brought by Mr Reynolds, who'd been the Taoiseach of Ireland. In the present case, the Court of Appeal stated, for example, that there was no material difference between the new statutory defense and the old common law one. Today's judgment, which charts the development of the common law defense and the changing drafts of the statutory defense prior to the enactment of Section 4, is intended in particular to highlight the difference between them.